Hello, beautiful people. Happy New Year to you guys. I hope you are doing great. This is the first time we're meeting in this new year, and I hope so far the holiday went really well and you are already geared up for the very new year. And hopefully, this year is going to be a great one for all of us, including immigrants here in the US. Okay, so last week we started recording a video on the public charge rule, the final rule that was updated in December of 2022. Now, this is the final part of the video. We are still reviewing the document that was released by USCIS in order to help us to understand what USCIS is going to be looking out for once you apply for an adjustment of status. Once you file an adjustment of status application or any other type of application that will require a determination on whether or not you, the applicant, um, will be deemed to be a public charge. Okay, so if you need more information on the preliminary issues of this subject matter, please review all our videos, and we have all those initial videos. That this is part 2. All right, guys, again, welcome to this channel. Let's jump into part 2 of the video. Now, we're going to be discussing what is an affidavit of support. Guys, remember that we already discussed what a public charge is. Once you're applying for a green card or some type of visa that requires a determination of whether or not you're a public charge, USCIS or United States Citizenship and Immigration Services will make the determination. Once you're applying, for example, to become a green card holder, most type of family-based applications will require that USCIS will review whether or not you're going to become a burden or you're going to become likely to be primarily dependent or depending on the US government for a livelihood or for subsistence or to live. They don't want that. So, they will do an assessment as to whether or not you're somebody who's going to become a big burden. If you're going to become a burden, your adjustment of status application or your request to be admitted to the US will be denied based on, your likelihood of becoming a public charge. Okay, so affidavit of support is one of the forms or one of the assessments that USCIS reviews. They will look at your the affidavit of support form you submit as part of your green card application to determine this. Okay, so now let's review. Let me share my screen. I think I have it right here. Affidavit of support. So the question is, what is an affidavit of support under Section 213A of the Immigration and Nationality Act? So, the Congress requires that certain immigrants, they will submit a sufficient affidavit of support. So, the way you do this is you either will fill out the I-864 or the form I-86EZ. Okay. Of course, some people are exempt from the public charge rule. So those people will fill out, for example, the I-86 4W. There are, other variations of the I-864, but for this purpose, we'll be reviewing, these two types. Now, your I-864 should be submitted as part of your adjustment of status application to show that you are able to, if you have a petitioner filing for you, that the petitioner is able to sponsor you and to make sure you don't become a public charge or you don't become a burden. Okay, so you fill out a properly completed form I-864 or I-864 is easy, depending on what applies to you. Okay. Now, the new section specifies who meet the definition of a sponsor, which immigrants must submit a sufficient affidavit of support, the scope of sponsors' obligations, and how the affidavit of support may be enforced. Let's take a look at these things. By executing an affidavit of support, what does a petitioner do? So, a petitioner is normally a US citizen or a green card holder who's filing for their family member. Now, as part of the adjustment of status application, the petitioner will be required to, they'll be required to fill out the I-864 again to show that they are able to sponsor the person they are petitioning to get a green card. So once you fill out as a petitioner the affidavit of support, you are normally agreeing to do a bunch of things, and you are entering into a contract with the US government. It's serious business, guys. You're entering into a contract with the US government, telling the US government that, look, here are the things that I'm willing to do. Let's go through them. The first one is that, you agree that the sponsor agrees to provide support to maintain the sponsored immigrant at an annual income of no less than 125% of the federal poverty guideline. But the guideline is 100% if the sponsor is on active duty or is in the military, okay, or is in the U.S. Armed Forces, and they're petitioning for their spouse or child during the period the support obligation is in effect. So what this means is that in order to become eligible as a petitioner, you need to show that, first of all, you, the petitioner, you are earning. So every year, the HHS, they'll release a federal poverty guideline for your household size. So 2022 poverty guideline, 2023 poverty guideline. And in order to petition for someone, you should be making 25% above the federal poverty guideline for your household size. Okay. I hope this is clear. Now let me pull up the I-864P. That will give you the guideline, Okay, it looks like we still have the 2022 HHS poverty guideline, as we mentioned. Every year they release this information, and then they'll show you, okay, if you have a household size of 2, how much you should be earning to be counted as 125, to be counted as 125% above the federal poverty guideline. So there's a federal poverty guideline, if it's here, in order to be a sponsor, you should be making 125% above that federal poverty guideline in order to qualify to be a sponsor. If you are in, let's say active duty or in the military, you're in the armed forces and you're petitioning your spouse or children, then your burden is you should be earning 100% above the federal poverty guideline. If you're a civilian like me, you're not you're not in active duty, then you should be earning 125% above the federal poverty guideline in order to be able to sponsor someone else. As I say, I tell my clients, what business do you have trying to petition for someone to get a green card when you cannot take care of yourself? You are relying on the US government. Let's say you're a US citizen and you're relying on the US government for sustenance. Like, you're taking, let's say you don't even earn an income. You're earning something really low. Let's say you're earning $10,000 a year. You are unable to sponsor anyone for a green card unless, of course, you get something known as a joint sponsor, okay, or a household wage earner. Those are different discussions, but I've recorded videos on all these things. But it's just to give you an idea. In order to petition for someone to get a green card, you should be making a certain amount of money. That's enough to take care of you, your household size, and then the intended immigrant. Okay, so now let me give you an example. If you have a household size of 2, you should be earning $22,887 a year. That's 125% above the federal poverty guideline for a household size of 2. If it's 3, it's above $28,000. If your household size is 4, above $34,000. So you should be able to show the US government through your filling out of Form I-864 as part of the adjustment of status application that you are earning as a petitioner 125% above the federal poverty guideline for your household size. Now, the second one is that you agree as a sponsor that you are going to be liable for any reimbursement obligation that's incurred from the sponsored immigrant receiving means-tested public benefits during the period that the obligation is in effect. Okay, so what this means is that if your beneficiary or the person you're sponsoring goes for any means-tested public benefit, so a public benefit, which the beneficiary becomes eligible for as a result of not having enough money or not having enough resources. So let's say the beneficiary goes to take some public benefit. And in order to qualify for that public benefit, they will check, okay, how much money does this person have? And they realize that this person is really poor, really, really poor, and so qualifies to take the public benefit. You, the petitioner, you will have to be liable to reimburse the US government for spending that amount on the intending, on the intending immigrant. Okay. I hope that's clear, guys. Okay. Now, the third thing that the sponsor agrees to do once he signs the I-86 contract that he enters into with the US government when he's petitioning for beneficiaries is that he agrees to submit to the jurisdiction of any federal or state court for enforcing the support obligation. So, where the government wants to enforce that support obligation that is due them because, for whatever reason, the beneficiary has taken those types of benefits and now the petitioner is on the hook, then you agree to submit to the jurisdiction of any federal or state court. The fourth thing is that the US government can consider the sponsor's income and assets are as available for the support of the sponsored immigrant when the immigrant applies for means-tested public benefit. Yeah, so once the immigrant applies for means-tested benefit, then the US government, the sponsor is agreeing that the US government will consider you, the sponsors or the petitioners, your income and assets available. Again, I should be, let's be careful here. A petitioner is not always equal to a sponsor, right? Because sometimes you can have a petitioner, he's a sponsor, but he has a joint sponsor, right? Because his income doesn't rise up to the required amount. So he adds on another sponsor. So that other joint sponsor, he may not be the petitioner for the application, but he will still be on the hook for all these types of things. Okay. Please note also that if you receive means-tested public benefit, then it doesn't disqualify you from becoming a sponsor. The fact that you yourself, you've gone for means public benefit doesn't mean you cannot sponsor someone. However, means public benefits cannot be included as income that is used to meet the income threshold. Okay, so you cannot use income from what the government has given you because you don't have enough resources to help meet the income threshold of 125% above the federal poverty guideline. And at the same time, just note that the fact that you've received public benefit doesn't disqualify you totally. You can receive public benefits, but then let's say you have your own income, you added on some public benefits, you can still sponsor someone depending on what the situation is. Okay. Now let me move on to the next page. Please don't forget to drop your questions and your comments, and then we will try to answer them in our next live video or in our next session. Okay. Let's go here. Hold on. Let me pull this up. What's going on? Okay, now which applicant for adjustment of status must submit an affidavit of support under Section 213A of the Immigration and Nationality Act? As I mentioned to you guys, not everyone needs to submit an affidavit of support. But most family-based applicants, they need to submit an affidavit of support. But of course, there are some exceptions. In our previous video, we looked at some of these exceptions. Okay. So there are some people that do not need to submit the affidavits of support. We have people who are employment-based preference category when some conditions apply. Then an immigrant investor. Yes, this one absolutely makes sense because there's some categories of visas that are available for people who want to invest in the U.S. economy. These people are investing sometimes $2 million in the US economy. So you don't need to ask them if they're able to take care of themselves. These people are clearly able. So they don't even have to submit an affidavit of support. Right. And again, with these type of immigrant visas, these people are self-petitioning. So it's very different. Okay. From the adjustment of status where you would normally have someone petitioning on your behalf. Okay, so human trafficking victim, teen non-immigrant visa, teen non-immigrant visas, or people applying for teen non-immigrant visas, they are not required to submit an affidavit of support. Victims of qualifying criminal activity, they are not required to submit an affidavit of support. Diplomat or high-ranking official unable to return home. Then the S non-immigrant visa or a qualifying member. The S non-immigrant, if you have important information to give to the U.S. government about, a criminal ring or something like that, you don't submit an affidavit of support. Because you see, with the T visa, the U visa, S visa, it's like the government needs you. They need you to be able to resolve crime in the US. So they know that a lot of times these people are victims, and so they may not be able to support themselves. In fact, they need help, so they don't hold these people liable. Like they don't hold them to that test that you need to be able to support yourself or have your petitioner support you. Then the diversity visa program, so the visa lottery people, and a bunch of these things. One of the following special immigrant categories: religious workers are not required, certain broadcasters, armed forces, American Act. So these are the list of people who are not normally required to submit affidavits of support as part of their applications, immigration applications. Yes, people who, asylees, if you're applying for asylum, you're already running from your home country, you're barely able to support yourself. You're not required to, submit an affidavit of support. Haitian Refugee Immigrants Fairness Act, Luxembourg Parolee, Cuban Adjustment Act, the registry, the registry where the green card registry, where you can apply for a green card based on continuous residence in the US since before January 1st, 1972. If you've been continuously resident in the US since before January 1st, 1972. So, for example, you came to the US February 1971, and you've been continuously resident in the US. You've been living here in the US for a long time. Since that time, then you qualify to get a green card through the registry method. Okay, then Liberian, under the Liberian Refugee Immigration Fairness Program. Now let's look at this. What is the purpose of Form I-864, request for exemption for intending immigrants affidavits of support, and who may submit this form instead of Form I-864? Now, the affidavit of support under 213A of the INA, Form I-864 or I-864Z, is required for most family immigrants and some employment base to show that they have adequate means of financial support and they are not likely to become a public charge. However, certain classes of immigrants are exempt from the Form I-864 or the easy requirements. But those people have to submit the I-864W. I mentioned this earlier. This is a request for exemption for intending immigrants affidavits of support with the adjustment of status application to establish that a Form I-864 is not required in that case. So if you are not required to submit a Form I-864, then you need to make sure that you're submitting the I-864W to demonstrate your your exemption from the submission of the I-864 form. Applicants for adjustment of status who must submit I-864W include applicants who, so these include four types of applicants. They submit the I-864W to show an exemption from the I-864 submission rule. The first one, people who have earned or can receive credit for 40 qualifying quarters, credits of work in the United States as defined by the Social Security Act. So this is normally for people who have worked for about 10 years or more in the US. Number two, they are under the age of 18, they are unmarried, immigrating as a child of a US citizen, and they are not likely to become a public charge and will automatically become a US citizen under Section INA Section 320. Under INA Section 320, upon admission to the US as a lawful permanent resident and taking up residence in the legal and physical custody of their US citizen parent. So this is pretty much talking about derivative citizenship. When we talk about citizenship, there are a few types. We have the automatic acquisition, then we have the derivation or derivative citizenship, and then of course we have naturalization. Naturalization is you're above 18 and you petition on your own behalf. You apply to become you're a national of another place and you're trying to become a US citizen. Now, derivatives are people who are under the ages of 18. Their parents became US citizens after these people were born, they come in as green card holders or lawful permanent residents, and they are normally in the legal and physical custody. They derive citizenship. So because they are under 18 years of age, if they are applying for the um upon admission as lawful permanent residents, then they are not required to submit the I-864. But of course, because even they're not, but then they have to submit the I-864W to demonstrate that they are exempt. Okay. Now the third is that these people, applicants who are applying under the self-petitioning battered spouse or child immigrant category, this is known as the VAWA or the abused green card. If you are, for example, the abused wife or husband of a U.S. citizen or green card holder, you can apply for something known as VAWA. We handle those types of applications. We love those applications. So if you are facing abuse, extreme cruelty, or battery, then you can contact us. And then when you're in this category, you do not need to submit an I-864 in its stead. You will submit an I-864W to demonstrate your that you're exempt and that you qualify. You have to submit the I-864W. Now, the last thing is you are applying as a self-petitioning widow or widower of a U.S. citizen. So this is the widowhood petition. You don't need to submit an I-864. You would rather submit an I-864W to show that you are exempt from the affidavit of support request. Now, what is the effect of a missing or an insufficient affidavit of support under Section 213A of the Immigration and Nationality Act when it is required? If an affidavit of support is required, that's the form, I-864 easy is required, but it's not submitted. Or if USCIS deems the I-864 easy insufficient because the sponsor failed to demonstrate the means to maintain income at the required threshold, that means that for their household size, the amount they are earning, then the intending immigrant becomes inadmissible on the public charge ground, and they'll just deny the immigrant application for adjustment of status or an immigrant visa. Okay, I have a little bit of my tea that spilled here. Let me just wipe that. Okay. All right, so that's the effect. What's the effect of not submitting? If you do not submit a properly filed 864 or easy, then your case could be denied. That's a person who's trying to become a green card holder's case will be denied. So you need to make sure that it's sufficient and you actually do submit one that qualifies under Section 213A of the INA. Okay, now when does DHS make public charge inadmissibility determinations? Let me skip to the next page right here. In general, all grounds of inadmissibility apply to immigration benefits that require an applicant is admissible to the U.S. That's required that an applicant is admissible to the U.S. Specifically, the public charge ground of inadmissibility applies to applicants for visas. So they're like, okay, when do they make this determination? If you're applying for visas, admission, adjustment of status, unless the non-citizen is exempt from the public charge ground of inadmissibility. Most commonly, we make the public charge inadmissibility determination as part of the adjustment of status application process. When non-citizens apply to adjust their status if you're trying to adjust your status from a non-citizen or you are trying to become a green card holder or a lawful permanent resident, then they'll make that determination. U.S. Customs and Border Protection makes public charge inadmissibility determination when applicants apply for admission who are subject to this inadmissibility ground. When applicants for admission who are subject to this inadmissibility ground present themselves for inspection at the port of entry. So far as you are subject, CBP will also make this determination. Okay. So, for example, you're coming in on let's say a B2 visa, and then they feel like you're coming to deliver and you may not be able to pay for the fees, the medical bills of your baby and yourself, then they are free to deny you admission based on this public charge rule. Okay, so if you're an applicant for admission, this rule applies to you trying to get a visa, and the list of things I read out. Now, how is the Department of State addressing public charging and disability determinations during consular processing of immigrant visa applications? We have to refer to the Foreign Affairs Manual for information about this. I've pulled it up, so we'll take a look at that before we leave. Or maybe we should do another video separately, yeah, because we're almost at 30 minutes. Let me see if I can squeeze that in. Okay, let's look at this. So we'll look at when we talk about we'll talk about the immigrant visa applications during processing of immigrant visa applications. We'll take a look at that. Immigrant visa applications, consular processing. Let me explain that. So consular processing of immigrant visa application means that you are outside the United States and you have a family member in the US and they've petitioned for you to come and become an immigrant. So you're going to get a green card through the process. So once you appear before the consular officer or the interviewing officer at the US Embassy in your country, they will also make a public charge determination based on your case. I'm sorry. Okay. So for that situation also, normally the petitioner here has to submit tax transcripts and also an I-864 so that will be reviewed by the National Visa Center and of course forwarded to the US Embassy where the beneficiary will be interviewed for his visa. Okay, the last thing here is the public charge. Is the public charge ground of inadmissibility considered when determining eligibility to file an immigrant petition on behalf of a relative? No. So the public charge ground of inadmissibility does not apply to immigrant petitions on behalf of a relative. So the I-130, there's no public charge inadmissibility rule. It's when you're doing the adjustment of status application, that's the green card part. INA 213 states that non-citizens inadmissible only based on the public charge ground, they may be admitted in the discretion of DHS upon the giving of a suitable and proper bond or undertaking. What policies and procedures does USCIS have in place to implement this section? So the answer is this: DHS regulations implementing the public charge bond provisions are available in 8 CFR 103.6. Additionally, USCIS's policies are found here. Okay, yeah. We won't go through, the public charge bond provisions. Maybe at another time we could do that. So I hope this video has been helpful. Let me just give you yeah, I think I opened the Foreign Affairs Manual. So let me see if I'm able to. I don't think so. I have no idea why. Yeah, I have it on my screen, but as usual, no, I won't be able to pull it up. But let me just see here. Let me see. All right, guys, I think it might take time for me to pull up what we want to discuss in addition to this. Essentially, we've discussed the public charge rule. In our next video, we'll be taking a look at, we'll do another overview of the public charge final rule and look at what are the factors that will be considered, the minimum statutory factors. So we'll take a look at the assets, education and skills, we'll take a look at the bond rule, family status, health, all those discussions, and then hopefully we'll be able to answer the questions that we have on the public charge rule. I hope this video has been very helpful to you guys. And Thank you for watching. Please, if you have not yet subscribed to this channel, please do. American Immigration TV. We're giving you the scoop on all U.S. immigration law matters, everything that you guys need to know about U.S. immigration law. And if you know an immigrant who's here in the US, don't forget to share our videos with them. You never know who could need US immigration law help, because look, I have clients out telling me, look, people think I'm a US citizen because I've lived here for a long time, but I don't even have papers. So don't take it for granted. Please share with them. This information could be very helpful to them. Thanks a lot for watching. Again, don't forget to like, subscribe, turn on your notification bell, comment, like, share, and hopefully I'll see you soon in our next video. Take care and bye.